Hi everyone, and welcome to our webinar today on shareholder divorce, remedies, tactics and valuations. My name is Michael King. I'm a director in Cleaver Fulton Rankin's dispute resolution team. For those of you that don't know us, Cleaver's is a leading commercial law firm in Belfast, providing a full service to both commercial and private clients. We place modern technology at the heart of our practice. We are pleased to be the first NI legal team to announce our decision to invest heavily in legal tech and e-discovery services to improve efficiency and facilitate quicker legal review and evaluation. We have recently recruited a new Director of Legal Technology and Innovation who will develop a new practice area, the Digital Service Group, which we're extremely excited about. It'll be one more add-on that we can provide to our clients. I'm delighted to host this webinar today. Cleaver Fulton Rankin advises on shareholder agreements and other company arrangements. It also provides advice and assistance in cases of dispute. When a shareholder relationship breaks down, it is essential for shareholders to know their rights and obligations, as well as how to value that company when they're exiting from it. Over the course of the webinar, you're going to hear from three specialists. I'm delighted to hear from them in company disputes, who will explain how to maximize the value of your business partnership in exiting the business, whether the dispute is resolved by means of a settlement or the court determines a valuation. The process of valuation creates challenges and opportunities. Once again, I'm delighted to have joining us David Casement, Queen's Counsel, Rory Donaghy, Barrister at Law, and Simon McAllister, who's a partner at Ernst & Young. The session will be split into three parts. Opening the webinar is David, who will cover remedies, the share purchase order, and the base for valuation. David practices as a barrister in England and Wales, as well as in Northern Ireland. David is a silk specialising in chancery and commercial arbitration and litigation. He is regularly instructed in large-scale disputes and involving company, LLP and partnership disputes, and representing companies, directors, shareholders, members and partners in other issues. He's one of the most eminent practitioners in this field, and we're lucky to have him here to speak with us. Secondly, you'll hear from Rory Donaghy. Rory will cover tactics, the application of discount in the valuation of shares in companies. Rory has practiced at the Northern Irish Bar for over 20 years, as well as being called the Irish Bar. His practice involves all aspects of commercial and chancery work, including commercial disputes, company disputes, intellectual property claims, and personal and corporate insolvency issues. Last but not least, you're going to hear from Simon McAllister, who will cover valuation, the process of valuing a company, and the issues that arise in contested proceedings. Simon is a partner in the strategic and transactions team at Ernst & Young. He leads the valuations, modelling and economics practice on the island of Ireland. He leads the development of business modelling options for transactions, decision support and advice on the development of feasibility studies, investment cases and business plans. We are delighted that these practitioners could give us some of their valuable time to provide some insight. Welcome everyone, and thank you for joining. Before I hand over to David to commence our session, I just need to cover some basic housekeeping issues to ensure you can interact with myself and the speakers, and the experience is as good as it can be. If you have any questions during the presentation, please type them into the question box in your Zoom control panel. We will have 15 minutes for the questions at the end, and I'm grateful if we could leave questions to the end rather than throughout. We have all asked you to turn your cameras off today. This is so we can record this session to share the video with you and others afterwards. Only our speakers will be seen if your cameras are off. I have now the pleasure to hand over to David Casement, QC. David.
Yes, well, thank you very much, Michael, and good afternoon to everyone. Thank you for joining us. I'd like to thank Cleaver Fulton Rankin for arranging and organizing this seminar on shareholder disputes. We did do a previous one over a year ago, where we talked about rights and obligations of shareholders. So I thought actually I would do a little recap, not too much, but just to set the context for what I really want to talk about today. So I'm just going to run through some slides just to highlight some of the main points. So this is what we typically hear in the context of shareholder disputes. I want out and I want to take my share with me. It can be put in other ways. I want you to leave and I don't want you to take very much with you. And there are various variations of the same thing. We talk about shareholder divorce at times because, well, for reasons that I'm going to come on to, as to the nature of those disputes. But it's fair to say that one can divorce in haste and repent at leisure. And one of the things I'm going to be looking at is whether there are alternatives for saving the relationship. Also, I'm going to look at the general principle that generally speaking, there is no such thing as no-fault divorce when it comes to shareholders in the absence of agreement. And further, we will look to see what sort of agreements the parties can make between themselves in order to deal with this scenario, and what happens if they do not reach that agreement, which is that the court will make an order and decide the terms. So finding alternatives, just on a practical level, and this is often overlooked, it has to be asked, what's the true nature of the problem that the shareholders face? And that should be identified as early as possible. Is it personal, structural, permanent, transitory, remediable? Also consider the legal rights and obligations of the shareholders and any relevant third parties. Now, these rights and obligations are going to be found in the general law and shareholders agreements, but they have to be considered at the very outset. And also to find solutions, create a shareholders agreement, enforce the existing rights and obligations in order to regularize the position, mediate, and mediation is a very important part of dispute resolution, and of course obtain advice early on. One of the biggest problems is when people proceed on the basis that they know or they think they know, and in actual fact they realize soon after, when it's too late, that they don't know what their position is and they don't know what the position of others is. So just going back to the point about there's no such thing as no-fault divorce absent agreement. The parties may have already agreed the basis upon which one of the shareholders can leave the company. You can have good leaver or bad leaver provisions in a shareholders agreement or in the Articles of Association. But the Articles of Association, and the secret and the clue is in the name, they are the articles upon which the parties have agreed to associate. So if they have not addressed the question of how one person can leave and what they will be paid if they do, what they will receive, what support they will be given thereafter, what restrictions they have thereafter, then they are at a disadvantage. However, you can create the agreement after the dispute has arisen, although it takes place in a less congenial environment than pre-dispute. So that's an important distinction to bear in mind. But the key is this: absent agreement, a shareholder must persuade a court that the affairs of the company were or are being conducted in a manner that is unfairly prejudicial to at least that shareholder. That's straightforward. That's the wording of Section 994 of the Companies Act 2006. That's the unfair prejudice petition that is brought by one party to the court, and it can be like an old-style divorce petition. Well, why do I say that? Because in the midst of allegation and counter-allegation, and numerous allegations and counter-allegations, there will be a lot of emotional upset, a lot of expenditure in terms of legal fees, and potentially a disastrous scenario for one party or the other, or both. So this is why we use the analogy with divorce petitions, in order to make people aware that if you can find an alternative and you can deal with problems early on, it's much better than finding out later. But if you do ultimately have to resolve it by way of litigation, then you will find that actually it's where both sides have got allegations against each other, and the court will be left to determine whether there has been an irremediable breakdown in the relationship and whether it's been caused by the unfairly prejudicial conduct of the affairs of the company. The court remedies themselves are set out non-exhaustively in section 996 of the Companies Act 2006. The most sought after is the share purchase order. That's when somebody wants either to be bought out, to have their shares bought by the others who remain, or they want to buy out the other shareholders, and in particular the wrongdoers. And very often, and normally, they want that to be on a pro rata valuation basis without a discount. However, there are other orders that the court may make. A, the court may make an order to regulate the conduct of the company's affairs in the future. B, may order the company to refrain from or to do an act. And just to give some examples of A and B, it may, for example, order for there to be meetings to be held. It may order that financial information is to be provided to the shareholders. And in particular, this is very important where there is an excluded shareholder, somebody who has been sidelined by the other shareholder or shareholders, and has been kept out of what they regarded as their entitlement, which was to be involved in managing the affairs of the company. But that access to information is something that the court could order. It could also order the reinstatement of a shareholder director whose employment has been terminated. That, I have to say, I've never seen that being done, because normally by the stage that the court comes to deal with matters, the relationship is so bad that reinstating the person is probably the last thing that they want or would be appropriate. The court can also authorize civil proceedings to take place in the name of the company, and in particular that is relevant where there has been wrongdoing, especially in relation to the assets, including the business opportunities of the company, and someone has breached their duty to the company, whether it be a director or a third party. And finally, preventing amendments to the Articles of Association, which is particularly useful where there is a fear that there will be oppression against the minority by the majority using its voting powers to remove those class entrenched rights that have been created for the protection of a particular class of shareholders, or indeed for shareholders generally. However, the important point to bear in mind is that the court can make any order in its discretion. So what you find in section 996 are non-exhaustive examples of what the court may do. Now, I want to raise some practical points in relation to the valuation of the company's shares, because if one of the main types of relief that the parties may seek from the court is a share purchase order, it's important to know what value may be attributed to the company and how the court will go about it. But even if this is not a situation where there is litigation, but the parties are proceeding amicably, it's very important to be able to identify how the shares may be valued. And I just want to begin with a few practical points which may not be obvious. First of all, directors and shareholders should be as informed as possible about the company's business and finances, and retain the financial records and obtain advice as to the value of the company and its business. Very often, the biggest problem we face in advising shareholders who are directors is that they always assume that it was somebody else's business to look after the finances. They have resigned themselves to the fact that they don't get the financial information, or if they do, they have paid very little attention to it. That is a very common problem. So be informed, it's your company, you need to be fully aware. A further point is this: do not do anything to destroy the quasi-partnership. Now, Rory, speaking next, will talk a bit about quasi-partnership, but for present purposes, it's a close relationship, especially in the context of a small company, where there is a personal relationship between the shareholders. It may be the shareholders are also directors. It may be that they're all involved in working for the company. But that relationship can be destroyed, and it can be destroyed unwittingly by shareholders. For example, in the case of a shareholder director who decides, whilst he wishes to remain as a director, he wants to leave his employment and resigns his employment. And as in the case of Phoenix Supplies, Mr. Larvin in that case decided that he simply wanted to give up his employment but retain his position as shareholder and director. The Court of Appeal said, no, if you've given up your employment, in effect, you've given up all the rights that come with a quasi-partnership. And that was, in fact, catastrophic in that case when it came to valuation and establishing that, in fact, there were certain rights and obligations. So that's very important. And another way in which it can be lost is if you have a white knight scenario. So the white knight scenario is where you have someone come in as an investor. Well, there is an open question as to whether it's possible for some people to remain as a quasi-partnership and other people to be mere investors. And there is a substantial argument that, in fact, that ends the quasi-partnership. Another couple of points is do not act adversely to the interests of the company, because that is going to affect not only the value of the company, but it may affect whether you are entitled to complain about any treatment that you have received before bringing your petition. So the final point is that you should not compete with the company prior to the resolution of the dispute and never breach your duties, again, for the same reason that it may affect your entitlement to relief, but ultimately it will affect the value of the business. There are a number of bases of valuation, and the bases all have their different permutations within them. I'm just going to focus on the main ones. So first of all, the income approach, including discounted cash flow basis and capitalized dividend approach. Secondly, market approach, including the capitalized maintainable earnings approach, and the balance sheet or adjusted net asset approach. The major question that arises is whether there should be a discount for minority shareholding, and I'm happily going to pass that over to the next speaker, Rory, who will deal with that issue. When it comes to the income approach, what we're doing is we're identifying discounted cash flow and attributing a present value to an assumed future cash flow arising from the business asset. And then to the aggregate of the annual cash flows, there are applied discounts reflecting the time value of money and certain types of risk. So the analysis aims to estimate the money an investor would receive from an investment using future cash flows discounted for the time value of money, often 5 or 10 years worth of cash flow plus a residual value that continues. And a permutation of that is to capitalize the dividend that are likely to be paid in the future. Several problems emerge with those just as a matter of practice. I mean, first of all, with the discounted cash flow, it is very subjective. It is something that involves subjectivity in terms of what the cash flow growth will be and also what the risks will be. And all of that based upon perhaps 1 year's cash flow prior to the date of valuation. Dividend approach, again, suffers from the difficulty of there perhaps not being a dividend history. But perhaps one of the main problems is that there may be there may be insufficient company records to identify what the forecasts are going to be going forward. The lack of detailed cash flow forecasts, I find, is one of the biggest impediments to using this approach. The capitalized maintainable earnings approach is, however, one which is based upon the prior performance prior to the date of valuation and looking to see what the maintainable earnings are, perhaps on a weighted average basis. And then when one has the multiplicand, which is the averaged, the weighted average of those years, then there can be a consideration of what should be put in and what should be taken out. So, for example, if one of the reasons why it is so poor is because one of the shareholders has unfairly caused the company to part with its assets, perhaps in his direction, then that would need to be reversed back into the valuation in order for it to be properly reflective. And likewise, for a multiplier, one looks at the possible comparables, whether it's a listed company or indeed it is another comparable company that has been sold. And clearly there are different ways of approaching that. Another alternative, and this is the third option, is the balance sheet or adjusted net asset approach. And this is generally used only when the business is no longer a going concern and will be wound up. Alternatively, it's commonly used to value investment holding companies such as real estate. In my experience, it generally leads, in the context of a continuing business, which is trading as a going concern, it leads to a lesser value than the other bases that I have identified. And finally, the date of valuation. This is in the discretion of the court, and the court can choose any date. The test is whether it is fair to adopt that date. But the starting point tends to be the date of the order. It can be earlier, it can be later. And one of the ways in which we tend to deal with it is we tend to ask for valuations as at different dates. But we have to be clear that the court is not aiming to give you the highest valuation that it can. It's not intent upon providing you with a free bet. So you will simply be able to have a number of dates and you'll get whichever is the highest. The reality is the court is looking to see what the figures are, and then you have to justify why it should be that date. A point which often arises is hindsight. Hindsight is generally not permissible because you are meant to be valuing the company as at a certain date. So matters which occur afterwards strictly are not admissible in order to carry out that exercise. However, the future may be relevant to what could reasonably have been forecast at the date of valuation. So one could argue that if something happens months after the valuation, that would be easily foreseeable by somebody who was looking at the valuation as at the date of the valuation. And likewise, there can also be a legitimate cross-check to ensure that the figures are not outlandish. So those are the points just to set the scene. And I'm going to now pass over to Rory. We'll do the questions at the end.
David, thank you very much for that, as ever, extremely instructive. I'm here to deal with the second section, which is the application of discount and the valuation of shares in companies. There is a possibility that when you're a minority shareholder that your shares may be less valuable than you think on the basis solely because you're a minority shareholder. If you can turn to slide 2, please. This is a controversial topic which covers whether any, and if so, what discount should be applied to a minority holding of shares. There are two main types of discount. First is a discount for lack of control, known as minority discount, which is what I shall mainly be concentrating on this afternoon. And the second matter is discount for a lack of marketability, which I'll touch on briefly at the end. We can turn to the next slide, please. Minority discount. In relation to minority discount, this can arise in the following 3 situations. 1, the company is a quasi-partnership. 2, the shareholders acquired their shares at a discount. And 3, the company is not a quasi-partnership and the shareholder has acquired their shares on an undiscounted basis. Turn to the next slide, please. Where the company is a quasi-partnership, often in seminars, concepts are bandied around in the presumption that everyone attending knows what they mean. I'm often reminded of the former commercial judge, Lord Justice Weatherup, whenever he said, just explain it to me on the basis that I am a 10-year-old, though I suspect he had to slow down when he was running circles around everyone attending his courtroom. Accordingly, this poses the question initially, what is a quasi-partnership? There's no specific definition, and each case will turn on its own facts. However, where a company exhibits some or all of the following, it will be generally considered to be a quasi-partnership, further to the principles set out by Lord Wilberforce in Ibrahimi and Westbourne Galleries. And they are an association formed or continued on the basis of a personal relationship involving mutual confidence. That's something that David touched on in his presentation. Secondly, an agreement or understanding that all or some of the shareholders then shall participate in the conduct of the business. And thirdly, a restriction on the transfer of the members' interests in the company, which will appear within the various company articles and shareholders agreements. The next slide, please. Those will be matters that will be familiar with people who deal with companies and who are watching today, and they already recognize those principles. So the question then is, what affect the minority? Having established that one is dealing with a quasi-partnership, it is necessary to consider the effect of a quasi-partnership in relation to a minority discount. In this type of case, a successful petitioner's case, shares will ordinarily be valued pro rata according to the value of the shares as a whole. This is the basic principle that's been set and established for a considerable period of time. The court considered it unfair that the minority vendor who had the sale forced upon him would have had to sell at anything other than a pro rata without any discount. Converse, of course, is true, namely where an order is made for the purchase by the petitioner of the shares of a majority shareholder, those shares not being valued at a premium. Next slide, please. The basis of a non-discounted valuation in quasi-partnerships was explained by Lord Millett in CVC. His lordship drew the analogy between a true partnership and a quasi-partnership, where the approach taken was to value the shares not on the basis of them being valued by the majority as the only purchaser, who would then offer relatively little for them, but rather as the notional sale of the whole business to an outside purchaser. The majority must act fairly in the sale in order to buy their freedom. In other words, to be free to manage the business without regard to the relationship of trust and confidence that once existed. Next slide, please. It should, however, be noted that this is not always the case, and it may be appropriate in some cases to take a discounted value where there are special circumstances. There are a number of different situations where those special circumstances can arise. For example, where the minority shareholder has acted in such a way so as to deserve their exclusion. This is therefore equivalent to a sale at their election pursuant to the articles, namely at a discount. Secondly, there can be an exclusion, but rather than seek to sell at an undiscounted basis, they have elected to remain as an investor. This feeds into one of the themes that David mentioned very briefly in relation to thinking that you know how to act and how to behave, which can ultimately be a catastrophic decision and therefore would lead to advice that should be sought at as early as possible stage. And thirdly, there may be a situation where the quasi-partnership has in fact been destroyed, wherein there's been a presentation of an earlier Section 994 petition that was wholly justified. Again, a further example where people may make a decision that can have catastrophic circumstances on down the line. In any event, however, regardless of this, the court has a discretion to order the purchase of the shares on an undiscounted basis. The exercise of the court's discretion is an important theme that runs throughout this whole exercise and originates in the relevant provisions of the Companies Act 2006, and I shall return to that later on in this presentation. It should also be remembered that there are occasions where the company's articles or collateral shareholders agreement provides for preemptive rights or restrictions on transferability, or for certain shares to have special rights or privileges which can impact on whether they're to be valued at a discount. Nevertheless, in a quasi-partnership under Section 994, the court can disregard such provisions in the valuation process. Next slide, please. The next situation arises where the shareholders acquired their shares as an investment or at a discount. When this has happened, the courts generally accepted the principle that such a person should not be bought out for a more favourable rate under a Section 994 petition, even where their predecessor was a quasi-partner or in a quasi-partnership. That said, this will be fact-sensitive and there is no universal or even general rule. And recently, the Court of Appeal endorsed the exercise of judicial discretion not to be deflected from the general rule, namely purchase without discount. That's the recent decision in 2019 of Sprint Room, which is of note in that it was a combined judgment of the Court of Appeal, which included Lady Justice Rose, who is to be sworn in as a Justice of the Supreme Court next Monday, therefore adding to the judicial weight of this combined judgment. Next slide, please. The final example of a minority discount arises where the company is not a quasi-partnership and the shareholder has acquired their shares in an undiscounted basis. This is a controversial area with two schools of thought existing. I propose to look very briefly at each one. Thereafter, I will address the escape route that the courts appear to be taking to avoid determining expressly which rule is to be preferred, although perhaps understandably so, as we are mainly dealing with first instance judgments, making it all the more difficult for a court in a particular instance to set out a principle on its own motion. The first principle is the Strahan and Wilcock and Irvine, which is the original school of thought that originated in the Strahan case and was developed in Irvine on the basis that there should be a recognition that you're dealing with a minority shareholding and it should be valued as thus. Accordingly, it was considered that there was a general rule that a company, which is a non-quasi-partnership, should have a minority discount applied unless there are exceptional circumstances that apply which point to a different result. The point here is that the court does not wish to accord the company a quality which it lacks, arguably moving the shareholding beyond its station. The point being is that where it is non-quasi-partnership, one is dealing with a different creature altogether from a quasi-partnership. The competing rule arose in 2014 in the case of Re-Blue Index. This school of thought arose from the proposition that a quasi-partnership should not be determinative of the general applicability of a discount for a minority holding. The court held contrary to the view in Strahan that there was a general rule that a company that is a non-quasi-partnership should not have a minority discount applied unless there are particular circumstances such as acquisition at a discount. The principle at hand being that otherwise it would defeat the purposes of Section 994 if the oppressing majority were entitled as of right to a discount over the minority shares, thereby shrouding the issue of fairness, which appears within the provisions of the Companies Act in question. And turn to the next slide, please. As one can see, these are very different rules and the outworking of which can have a major effect on the valuation process at the outset. In the face of such opposing principles, it is not clear which rule will win out. There have been occasions where the court has retained an adherence to the general rule principle that there should be a discount, as seen in the decision of Mitchell and Mitchell. This decision is of note that in that Judge Briggs addressed the controversy relating to the two competing rules, and not only in the case law, but also in academic texts. And in that case, he plumped for the Strahan rule of there being a discount. Equally, there have been occasions where the court has held that the general rule was there should be no discount, which prevailed both in the Reed Lloyd's Auto Body Ringway case and also apparently in Mr. Casement's case of Waldron and Waldron. The courts also have on occasion not decided which rule is preferable, thereby standing on the sidelines as this war has been waged. The court has sought a way out by relying instead upon the discretion that the court has under the provisions of the Companies Act to reach a view as to whether there is to be a discount or not. In the case of ATM Coffee, the court decided that nothing less than a sale and purchase of the shares at a non-discounted valuation will do justice and amount to a fair price. Next slide, please. The preferred view is arguably one which is not caught by binding rules or doctrine, but rather is led by the principles set out in the language of Section 996, which of itself gives a broad discretion, albeit one that should be exercised judicially. In other words, to arrive at a valuation method which is fair in light of the facts of the case. Similar approach has also been taken in other cases where there is no presumption in favour of a pro rata valuation, though the facts of the case may in fact point to such a decision. Next slide, please. Where there is to be a discount, the question then arises as what choices of discount are then available? Very often the choice will not be between one extreme or the other, i.e. undiscounted or a fully discounted valuation. The court can and has, considering the facts of the case, found itself somewhere between the devil and the deep blue sea, so to speak, and the court is entitled to take a fair basis of a reasonable ground at a notional arm's length negotiation, which can of itself allow for a reasonable middle ground to be taken. Where there is a discount, the court will calculate the discount in light of all of the relevant circumstances, which can include the conduct of the respondent in obtaining the majority interest in the first place. The next slide, please. This perhaps leads to the most important question in relation to the issue of minority discount regarding non-quasi partnerships, namely, which rule will win the day? There's one thing that lawyers, accountants, and companies do not like, and that is uncertainty. One of the difficulties in this area is to try and predict just where the court is likely to go in your case. This is not necessarily such an easy matter to predict in light of the fact that there are two competing rules in this area. It will only become clear which rule wins when it is decided by an appellate court. Now, if I was a betting man, which I am not, unless you count my 50p each way in the Grand National last Saturday, I think that the pervading principle of the exercise of judicial discretion will win the day, taking account of the facts of the case before the court and thereby allowing room for there to be no discount without slavishly being tied to such a rule. What this means is that the court will take account of all of the facts of the case before it and before determining whether there should be a discount. Next slide, please. I want to touch very briefly on the secondary issue, which is a discount for lack of marketability. Unlike a public limited company, there is generally no ready market for shares in private or non-listed companies. For example, there's no stock market to rely on. If this applies, then the exercise is undertaken after any minority discount has been applied. This will be a matter of expert evidence that the court can and does take into account whether the petitioner has been unfairly prejudiced, in which case there will be no discount, as indicated in the Anacott case. Next slide, please. To conclude, I would say as follows. The principles that apply in discount cases are at times relatively straightforward, yet at other times rather complex. Establishing the type of company that you're dealing with is very important in determining the principles to be applied. Let's hope that the appellate courts will provide some further guidance in the area of non-quasi partnerships. In any event, even in the most complex situations, the facts of the case will be vitally important. It's now time to hand over to Simon, who's a forensic accountant, will demonstrate the variety of skills and judgments that are required to calculate the said discount, as well as the much bigger picture as was outlined by David. Thank you.
Thanks, Rory. So I will just bring up some slides I'm going to use to talk through a couple of topics around the issues that people will see in valuations. This won't leave you with an ability to do a valuation. It is aimed at trying to give you the basics around what are the key concepts, what questions should you be asking, how do you understand what's being put in front of you, for example, when you get a valuation report, and give you an idea about some of the process that we'd go through as a valuer. I suppose one thing just to say straight away, and the sort of point of this quote is that, you know, the one thing you're probably guaranteed to get with valuers is that you won't get two valuers who will give you the exact same answer. And clearly in an adversarial situation, that is absolutely going to be the case. And, you know, that being the case, it's important to acknowledge, and we would always be very upfront in saying that valuation absolutely has art as well as science. You need to be comfortable with there being uncertainty about the future. You need to be able to resolve some of that uncertainty and potentially then conflicting views, and particularly in a dispute scenario, and David mentioned allegation and counter-allegation, that will be the case as it comes to the valuation as well. You'll have one side who say the future is absolutely bright, the business is worth gazillions, and you'll have others who are saying the sky is falling in and the business is worthless. And then the second thing is that getting a valuation in a dispute process in particular is really only half the battle. And the remainder is actually defending it and making sure that it will stand up to required scrutiny, either from the other side or from a court if they're adjudicating effectively, as Rory has alluded to there, particularly with the issue of discounts, a court is adjudicating on what they believe. And if you want to see what can happen when that isn't done right, there was a case in early 2020 in the Irish courts. It was Harrington v. Harrington, and each side had their own expert, and both experts were heavily criticized by the judge in making the judgment at the end of it because of various deficiencies in their work, part of which was arguably being somewhat one-eyed about the prospects of the business. So just a quick introduction about the sort of spectrum, as I would call it, of valuations that can be used, or valuation services that can be used in a dispute situation. The first is just the area of planning, and we'd always be very clear that we would advocate being involved up front with your legal team in particular to advise on some of the valuation issues that may be at hand in the matter. Talk about, you know, what we think will work as a basis for a claim, where will vulnerabilities be, and plan for that before the train leaves the station, as it were. And we've had situations in the past where we're brought in very late, the argument has been set, but the valuation implications effectively have been considered, and they don't then align with where the claimant would like it to be. Mediation and arbitration, you know, so some sort of consensual process. So we're effectively then helping with trying to get to a settlement, but clearly working for one side. And usually that will involve meeting with the other valuer, if there is one, and debating with them, usually trying to find some sort of common ground and identify areas that we don't agree. Expert appointments, so they are usually where we are appointed under a specific basis. So that could be a court order, or it could be a defined basis by the company under something like the articles or a shareholder agreement. And I'll touch on binding and non-speaking later on. And then formal litigation, where our work ends up being a submission to the court. We become an expert witness to come in and speak to our work and be cross-examined on it as well. So briefly on some of the valuation concepts, and you've heard some of them there, but I suppose a couple of theoretical things first. I mean, a valuation is all about the future value of a business. So the historical value is, you know, eaten bread and all that. So with the exception of what cash has been generated in the past, the value is largely in the future. And that's why the future is so important. And we've talked there about forecasts and about the difficulty of getting cash flows. And a business can then have value from cash flows either into perpetuity, so going concern effectively, or they can be finite. So something like a wind farm where the turbines have to be repowered, or where a business is in liquidation. And then, and David touched on this, a point in time. So valuation is only valid as of a particular point in time. So the value of something today will not necessarily be the value if we use a valuation date next week. And as he mentioned, the use of hindsight is not admissible. And I don't mean that from a legal perspective, though that applies as well. But valuers have to only use the information that is known or would be knowable. So even if you didn't know it, but you should have known it by making some sort of reasonable inquiry, that's what you can use. So briefly enough, the key components of evaluation, and I'll touch quite quickly on each of these as we go through. So there's the basis, which is the conceptual framework that you're doing it under. There's the methodology that you use, which has been touched on earlier. There's the analysis that we go through, and then there is the report that's prepared to summarize your work. So the basis of value, and this is something that's very poorly understood. It can cause problems, and we've seen it cause issues. So it's an important piece to be very aware of. You don't need to know the detail of all this again, but to be aware of it and make sure that it's agreed at the start. And the basis of value is not the method of the value. So we heard mention earlier of, you know, market approach or discounted cash flows. That's all methodology. This is the basis under which those methodologies will be applied. And you can get a different assumption or you can get a different number for a specific assumption depending on the basis of value here. So we have these different types of bases of value, and then number 5 is other bases. So there's about 10 or 15 different bases that will be recognized amongst the valuation community. The most common one is market value. It would be the one most often used for many disputes. And that is one that talks about there being a market. So it should be something that can transact without too many impediments, that there is a willing buyer and a willing seller, that they are equally well informed, there isn't some huge asymmetry of information, and that everybody is acting in their own self-interest, or you could read rationally, which of course isn't always the case, particularly in disputes. Open market value, much more common in tax valuation. So this brings in then the theory of a hypothetical seller and buyer, which is slightly different, again, depending on how you think about some of the information that you would use. Equity and fair value was mentioned earlier there by Rory. And this fair value is one where, as a profession, we haven't helped ourselves by having a few different fair values. So there is a fair value which effectively equates in most people's mind to equitable value. And that's about what's fair under the classic sense of the word. And for those of you who have children, you know exactly what I mean when one gets one and one gets another. So this is much more about a restricted market where you're thinking about the specific seller and a very limited number of specific buyers and what is fair to each side. Fair value for financial reporting, in contrast, is for a different purpose, and it's done for different things. And then we have special bases. So for example, the investment value, which is the value of an asset to a very specific buyer under a very defined set of circumstances. So it's not something that will be available to the full market. So each of these are different. They carry their own nuances, and it's important to be very clear at the outset as to which one's being used. The methodology, and this was touched on, so I won't repeat it in too much, but there is 3 broad methodologies that can be used. We would always aspire to use 2 if we can. One brings in the risk, recognizing our own vulnerability or the uncertainty that we're managing, that you're using a single point of failure. So 2 valuation methods should be used to try and cross-check each other. And those 2 should be the 2 that are best suited to the specifics of the business and to the facts and circumstances. So the analysis that we go through then, this is the sort of broad approach if you're taking a typical valuation. And the first part is getting the financials, really understanding the information that's available, understanding what sort of forecast information can we get, how do we understand the outlook for this business, do we need to adjust any of the financial information for any non-recurring information, for example, or non-recurring items. So last year, for example, the business got a big insurance settlement. That's swelling the bottom line, but it's not actually recurring. Those are things that you would need to adjust for. And also more a problem, let's say when we were doing valuations 10 years ago, coming out of recession or in recession, whether, for example, a capital structure is sustainable, so too much debt. So the kind of key things then that we would think about with each of the methodologies, the income approach, as mentioned, the key thing is about the forecasts. And as we know, paper won't refuse ink and spreadsheets won't refuse numbers. So forecasts can be created, but how do we get comfortable that they are reliable? So there's an amount of work in that. The market approach, the difficulty there and the challenge is always about getting comparability. In that case, I mentioned Harrington v. Harrington. That was the bulk of the judge's criticism, was that the businesses that were presented as being comparable to the valuation at hand weren't really comparable at all for various reasons. The cost approach, very suitable, as was mentioned, for asset-heavy businesses, so property companies, big energy businesses in many cases, but not always suitable for other businesses. The key thing there will be whether the values that are in the balance sheet at book value are really a market value, and do you need to revalue them? Because the accounting world sometimes overlaps with the commercial world, but only sometimes. And then what sort of adjustments do you need to make for non-operating assets? You could have a business that, a family-owned business, and they have a couple of apartments owned by the business because they've been investing money and diversifying, but those apartments have nothing to do with the business. So you need to adjust them out. Make sure you don't have any of the cash flows of it. Take out the debt that relates to it. And then there are a host of other adjustments that I won't go into in detail, but things like, and we've touched on discounts, which we'll talk about slightly separately, but there's a lot of work in making sure that the valuer understands what the information they've been given is, and the reliability of it. Now, it's important just to mention that understanding that information is not the same as doing diligence on it. A valuer will not typically say, or will not undertake procedures to validate the information. This is not an audit. There's an element of needing to rely on the information that's being given, which doesn't mean accepting it verbatim, but it means accepting that the numbers have been recorded correctly, which we can then make certain adjustments off if we need to. I'll very quickly just skip past this one because I'm going to be tight on time, but the slides I'm sure will be available afterwards. But just to mention that the area of multiples is one we often come up against. Multiples are very intuitive. Everyone likes to talk about 10 times, EBITDA, or 20 times revenue if you're a technology business, or whatever the case may be. But there's a lot of caution needed in picking multiples because they can be quite difficult to get right, and they will typically require adjustment. The other point to make is that different industries will have different multiples and different rules of thumb that they may use, and rules of thumb being the operative word there, that it may not be something that you would take into a dispute valuation, but it could be good for an initial conversation about something. So, for example, the hotel sector talks about the value per room, or the exploration sector talks about the value per square kilometre of land that you may have licensed or optioned. So different industries have all their own different multiples. How they get calculated is slightly different, and how they would apply is slightly different. So what I've kind of called the report, I mean, this is to give you an idea of the kind of work that goes into preparing a valuation report. The first week or two, generally, we would budget with clients is consumed with getting the thing kicked off, agreeing what is the background to it, understanding the background to it, agreeing the scope of the work that we're going to do, agreeing things like the basis of value so that we're all starting off from the right place, and then being clear to the client, what information are we going to need? And that may not always be sitting on a shelf, so there needs to be a bit of time to go and get that information and come back to us. So part 3 then is the bit where the rubber hits the road for us. That's doing the analysis, understanding the business, the sector, doing the calculations that will underpin some of our methodologies like discount rates, which I won't go into in detail, or calculating multiples and so on. And then drafting a report, which will include enough information that a reader will be able to pick that up cold and understand what's being done, why is it being done, what's the basis for the valuation, what's all the background to the business, the prospects, and then the analysis that's been done, so that the valuation conclusion can be supported from that report without recourse to something or someone else. And one thing to mention is from either a cost or a timing point of view, that is usually the bigger driver of it. And we have regularly seen valuations where they may be 1 page long, and it's someone just really not doing a whole lot of work, or they're doing it in 3 or 4 days. And I would always just advise caution. It's like getting a quote from your builder. If one guy's saying it's 2,000 and 3 others are saying it's 20, there's probably a reason why the cheap one is cheap. So, we don't recognize phrases like indicative valuation or desktop valuation. A valuation's a valuation as far as we're concerned. Once we put a number out there on our letterhead, that number has legs, and it runs away from any control we may put on it. So just quickly on some typical issues then that we see. So, reporting is one issue, and I touched on speaking or non-speaking earlier. And the concept of a non-speaking valuation is one where there is no detail provided. Now, that's not the same as what I'm talking about earlier of a 1-page letter. That's not doing enough work. This is where typically you're appointed as expert, and it's going to be binding. And we will say, or the letter will just say, we've been appointed, this is what it's for, and the value is X. And that's it. And the logic for that is to not put in all sorts of extra detail that both sides can then start arguing about. So if both sides can agree that it's going to be binding, and if they agree it's a non-speaking valuation, that tends to be quite a productive resolution to disputes, because you're not giving areas for subsequent debate. The nature of our appointment is really important. So if we're being appointed under a shareholders agreement, we need to be clear that that is the case, because we need to be clear about what other conditions may come with that appointment. For example, a basis of value, or for example, whether a minority discount would apply or not, may often be addressed in shareholders agreements. It also drives who we get appointed by. So are we being appointed by the directors, or by the shareholders, or by a specific shareholder? And each of those will come with different complications. The nature of the finding is about it being binding or not, which I touched on earlier. So if it's an expert valuation, it will often be binding. But if it's a dispute where both sides are taking their own advice, it would be non-binding. Minority discount, Rory has talked in great detail about, and some super information there, which I won't talk about, other than to say it is always an area of disagreement. And if you're at the point now where you're thinking about avoiding a dispute and you're drafting a legal document, whether a shareholders agreement or a share purchase agreement or any document where you may cover this, address the issue of minority discount. Whether you have one or not is up to you, but at least address it, because it takes a huge source of disagreement away later on. And then the final one is about the conduct of the work. And that's about how the valuer will work in doing their analysis and presenting their findings. And largely that's about, will they just deal bilaterally with either side? So I'm talking primarily now if it's an expert appointment, or will they have to speak in a situation where everybody hears what's going on? And that's always just, excuse me, fact and circumstance dependent, but it will have implications for how complicated the work is going to be, how long it's going to take, and so on. So I'm right up against time now. I want to just have a chance for one or two questions if there is any. So I will leave it there for my slides and ask David and Rory if they'd like to come back on screen.
Thank you, guys. Thank you, David. Thank you, Rory. Thank you, Simon. That's certainly insightful, and it's a lot of food for thought. Just checking if there's any questions. There's none on our chat function. If anyone would like to ask a question, if you even want to unmute your microphone, and if you want to come forward. Well, I think while we're waiting for questions, one issue that I've been thinking about was, in other jurisdictions, you're talking about the appointment of a single expert rather than an expert per parties. I mean, what are the views on that? Do you think it's something that would be appropriate for Northern Ireland? And is it something that's on its way anyway?
I can maybe kick off. I mean, I think I'd go back to my initial comment that, the one thing you're guaranteed is that two valuers will get two different answers. A dispute has arisen usually because of other reasons, which is largely that the parties may have fallen out. So that is the dispute. You don't want the dispute to subsequently become about the value, though inevitably that's where it leads. So I think, if there is a potential through a joint appointment of a single expert, I think that does take some of that additional tension out of it. I think if it's something that can be done, without causing other issues, I think it is a productive step. There has been rules introduced under the High Court, the new High Court rules in Ireland a couple of years ago, to allow for a bit more easier process around single appointment, and also for a process, the sort of hot tubbing process they call it, where you put the two experts in together and try and get them to come, as I mentioned in arbitration there, try and come to common ground, so that by the time it gets to the sort of nub of the conversation, all of the areas of agreement have been put to one side, and then you're just left with the key disagreements. So I think generally, there would be something we'd be in favour of as valuers in the interests of getting to a productive conclusion.
Well, at the risk of striking a discordant note, just from the lawyer's point of view, from counsel's point of view, I think it depends on the value, but pretty soon you get to the point where the value of the dispute justifies having separate expert input. I think it's a very attractive argument to say if you've one expert, you remove all of the areas of controversy. Effectively, that makes the expert effectively the judge in respect of the various areas of dispute, whether something should be reversed, what is maintainable, what are the risks in respect of cash flow. But I think, as with all areas of litigation, the greater the controversy in respect of those areas, the more likely it is there will be separate expert input. And certainly in England and Wales, in terms of getting court directions, the court is likely to appoint separate or give permission for separate experts to give their evidence, as long as the value justifies it. And I think anything in excess of certainly £1 million for the value of the company in total, I think would justify separate representation. It's different if the only area of dispute is the value of a piece of land or some of the assets that are held. That's a pure valuation exercise. But in other matters, you have to build up your factual basis. In other words, you have to get your lay evidence together. So there will be witness statements, there will be affidavit evidence, whatever it may be, which will be used in order to address highly controversial areas, which ultimately the expert will have to give an opinion on. But the expert can also be involved at the outset in terms of advising as to what type of evidence might be required in order to get them to a certain point. Very difficult to do that if you've only got one single expert.
I think certainly picking up, I would tend to agree with David. In Northern Ireland, we are somewhat behind the rest of the UK in relation to the advancement of matters in relation to appointing single experts. It tends not to particularly happen. We will not have the exposure of the size of case that David will ordinarily be dealing with. Is a much larger jurisdiction to deal with, a lot more money. So I think it'll be something, a single expert will be something that may well have to be foisted on parties. There's a healthy Northern Irish suspicion of things. And the point being is, if, as David said about having an individual, you lose control, and each party will want to have a degree of control, albeit that's tempered by the experts' declarations. So I think that whilst the disputes in general will be smaller, it will take some time for there to be a single expert being appointed in cases, just because we have a bit of a distance to travel.
Yeah, I think, David, it's a good differentiation on the degree to which the facts are disputed, actually, because the more the facts are disputed, the more of a burden you're putting on the valuer, not just to do the valuation, but to wade their way through establishing the facts as well. So I think that's a good differentiator.
Thank you. We have a question in. One of the speakers had mentioned arbitration briefly. The questioner's asked, is it not the most cost-effective approach to resolving disputes, and is it regularly used in NI? I mean, really what we're talking about is, when are Section 994 applications come into play in a dispute, and are there situations where arbitration is possible, and is it better than the court procedure?
Yeah. There used to be an argument that said that arbitration could not be used in the context of a Section 994 dispute. The reason being that it was to do with companies, it was to do with the potential range of remedies that might be available, which include, and we didn't touch on this, but because it's so rarely used, but in theory, could lead to the winding up of the company. That is one of the powers that exists, although it's very rarely used and would only be as a very last resort. That was all laid to rest in a very famous case, which actually involved the Premier League. And it was a case that was brought by Fulham, who were disputing as a member, as a shareholder of the Premier League, the conduct of certain conduct in relation to the league. And it was made absolutely clear by the Court of Appeal that actually arbitration, you can have a Section 994 dispute and all the remedies available. If it came to winding up, yes, that might be something which only a court could do, but certainly you can certainly have a shareholder Section 994 dispute in arbitration. And I agree, it is something that should be considered, because arbitration is confidential, it's private, and that's in the interest of all parties. But the reality is, if you've not agreed it in advance in a shareholders agreement or in your articles, you're not going to be able to do it unless you can agree subsequently. And it's very difficult to get shareholders to agree subsequently once the dispute has begun.
Thank you, David. And what about mediation, Rory? I mean, is that regularly used in this type of dispute?
Well, it can be. It is something that has a lot of attractive elements to it. For example, confidentiality. One of the difficulties about whenever you come with a Section 994 is that they, unfortunately, all the dirty linen is washed and can be washed in public. And that can be quite a distressing situation for the parties at hand. It also opens up a company, and if you're dealing with a bigger company, people don't like to see the background, the mechanisms, and so on and so forth. So in relation to mediation, there are a lot of pros in relation to the use of mediation. One may venture is that mediation it can be a quicker aspect than arbitration. It can be a less expensive. That's one of the allegations against arbitration, although arbitration started off as being a cheaper version in relation to court litigation. So it is always something to advise your clients is that there are a full armory of alternative dispute resolution mechanisms available. So my advice would be is to advise your clients about the availability of a number of different options. That shouldn't always necessarily be one that we end up going to the High Court or to the Rules Building in London, as the case, or down in the Four Courts in Dublin, as the case may be. So you should always be alive to the different options that are available to your client.
Okay, thank you. Simon, when you're being instructed in the Republic of Ireland, is it ever in the context of arbitrations or mediations, or is it generally when it's got as far as the door to court?
No, we would do several mediations a year. I think precisely for the reasons that Rory has mentioned there. I mean, if you can avoid getting into a full court setting, I think that's generally a more productive outcome. And certainly the confidentiality aspect that David touched on is something that people would be quite sensitive to as well. You know, not necessarily just for the sensitivity to values or anything else like that, but you know, again, it's ended up here because it is a dispute and people have fallen out, and you know, the kinds of communities we're all in where there's only 2 degrees of separation. People don't want that out in public or all the gory details of it. So yeah, we would see quite a few of them typically.
Great, thank you.
Yeah, I should say that I'm not convinced that arbitration is necessarily cheaper. Remember, the big difference between arbitration and court, well, there are a number of big differences, but one difference is that you do not have to pay for the judge to sit there day on day, but you do have to pay for the arbitrator to sit there day on day, and that can be very expensive. The real advantage is not so much cost in arbitration. The real advantage is confidentiality. You do it behind closed doors. The result is confidential. The materials that are deployed are confidential. That's your real value. And if you want to keep going with a business, somebody wants to keep that company going, it's probably in their best interest to try to keep it as low key as possible. So arbitration's ideal.
Yeah, I mean, it's a good point actually, just about we didn't really mention the commercial consequences of some of this. I mean, particularly smaller businesses, you know, some of their customers may be put off dealing with a business where they think that an implosion is imminent because they would fear a continuity of supply issue. So, you know, again, to the extent people can resolve things internally, that's usually better for the business as well.
And I mean, guys, do you think there's anything particularly about these type of disputes, both from a valuation and indeed a litigation perspective, that makes them much more tricky to deal with than other commercial disputes?
Well, these are intimate disputes. The relationship in the context of a small company involves going back over a number of years of, we agreed this and you didn't do this, and we agreed this and you didn't do that. And that's why I say there is the allegation and the cross allegation. So they are very fiercely contested. And if you have a family dispute, and Rory mentioned the Waldron case that I was involved in, that was a family dispute, family-owned company. So that just takes it on to yet another degree of intensity. So the earlier these things can be resolved, the better. The forum, if it can be arbitration or in mediation, then all to the good. It'll save cost, it'll save the angst, it will save, may even save the business as well. So everybody should be looking for an early resolution to resolve the problem so everybody can continue, or if they have to go their separate ways, for them to do that as quickly and as cheaply and as amicably as possible.
Yeah, I think picking up on that, it's almost like turning the traditional phrase we hear in the movies on its head. It's personal, not business. And in that sort of situation, people, and it happens in various different elements of the law, people can lose the run of themselves and not see the bigger picture in relation to the future, in relation to the value of their shares, in relation to the value of the company, in relation to other people's lives, and get caught up in these personal fights. And I think that's one of the difficulties, and trying to dampen that down and let people see that there is actually a bigger picture rather than just the two siblings or whatever who are in the room who can't stand each other. That there is a bigger picture, and that's where I think the skills of your own legal team, and as well as the methodology that you use to try and resolve it, are imperative. Because at the end of the day, there's nothing. No one is ever going to thank you if all of the money is used up in a small company in relation to fighting this to the bitter end.
Yeah, I think, Michael, they are necessarily that bit more difficult. I think, and from a valuation point of view, we feel that when we're sitting with a client, particularly an SME or a family business, where, frankly, if we were higher by 10%, or if the outcome is higher by 10%, that makes a big difference to people from a family finance point of view, where this business may be their sole means of supporting themselves or supporting the family. Take two large corporates who are in disagreement, and frankly, they would nearly value the certainty of or the speed of resolution over that 10%, whereas the irrationality then of the family aspect will creep in, that erodes those potential benefits of doing something quickly or doing something without further rancor. So the family ones, more so than just normal shareholding groups, I think always adds a degree of complication to it, and it can be quite difficult for advisors, to try and make sure they stay, in a position where they're being, where they're not getting sucked into some of the emotion of that, because they do get very emotional, and then subsequently they get irrational.
And can I also make a pitch for mediation as well? Because mediation is about facilitating the parties to come together for an agreement. Arbitration is when an arbitrator imposes the agreement on you. It's almost like a private court. But mediation, where you're getting the parties to agree, they can agree anything. They can be very flexible and very imaginative, and they can do far more than a court or an arbitrator could ever do. One example is you could have an in specie division of assets. The court can't do that. The court can't say, well, I'm going to order you to pay a certain amount, but I'm going to give you that bit of property, and I'm going to give you that business, and give somebody else something else. The reality is that with a mediation, the parties can be ingenious and inventive in terms of what the solution is. And they can come up with solutions that a court cannot. So it's not only cheaper, but it can actually be more effective. And if you have the right mediator and the right scenario, and everyone feels as though they've got the information available to them, therefore they can sit and talk meaningfully about a solution. I think that should be a precursor, in my view, for every piece of litigation and arbitration. So in other words, do your mediation first before you go to a trial. Do your mediation first before you go to an arbitration final hearing.
Yeah, and I think that's certainly the case for family disputes, where the nuance within families is not something the court will either pick up on or, so for example, the settlement could be that for one side, cash is really important and they want to be out, but for other participants, it's about actually X, Y, and Z part of the family continuing to have a job with the company. So, I think that's the creativity that David's referring to, that there can be, it's not just about coming down to a single number, it's about getting an overall settlement that keeps everybody happy, or at least equally unhappy.
I think also there's one point just following on from that is sometimes it's not just about the obvious. Sometimes it's not just about the pound, shillings and pence. And sometimes, and that's one of the beauties about mediation, it allows people in a confidential environment, it allows the mediator to mine down. And you may well find out that some arguably relatively innocuous thing, resolving that can be the key and can unblock everything and allow everything to flow. When you're there in a court situation, or arguably there in an arbitration situation, you lose the advantage of that. You allow the ability to it allows in one sense the tension between humanizing a situation and also to being strictly a commercial situation. And in a family and a small company, those two things can be very, very close together and can be intimately linked and overlap. And I think that's one of the elements, I think, perhaps following on from what David was saying, is the beauty of the whole thing is it allows that to evolve and develop.
Well, thank you, everyone. I think that's all the time we've got questions for. Thanks for listening and thanks for the questions. Once again, thank you, Simon. Thank you, Rory. Thank you, David, for providing some really useful insight there and giving some of your precious time this afternoon. If you didn't get any questions or you need anything further on this, please don't hesitate to contact our speakers or even myself. I'm contactable at m.king@cfrlaw.co.uk. To conclude, on behalf of Cleaver Fulton Rankin and our speakers, I would like to thank all of you for joining us today. Hope you found the information delivered and the questions addressed useful. I certainly did. Have a good afternoon. Thank you, everyone.